So the Supreme Court issued a 5-4 order, which has just completely shaken up the country and has created a battle between the state of Texas and the Biden administration over the border. So let's talk about what has now happened in the court battles since that Supreme Court intervention. But real quick before we jump into this video, I want to thank one of the main supporters of the channel, which is 1st Phorm. 1st Phorm is an amazing company. They make amazing supplements, and they also believe in pro-freedom. They believe in the Second Amendment, and they believe in supporting this type of content. And one of the cool things that they're offering you guys is if you sign up and it's your first time coming to 1st Phorm, you'll get 30 days free trial of their app. So check them out using the links down below. And thank you again to 1st Phorm for sponsoring and supporting this 2A content. As I mentioned in the intro, we need to talk about the 5-4 order that was issued by the Supreme Court on the whole Texas border issue and the dispute there, and what now is developed in the lower courts. This order by the Supreme Court not only impacts all of us in the nation, but it also shines more light on what the current Supreme Court's position is, and maybe where some of these justices will rule on critical issues also involving the Second Amendment. The case we're going to be talking about in this video is the Department of Homeland Security versus the state of Texas. This is a case and decision by the Supreme Court, an order by the Supreme Court that has got a lot of publicity. Recently, Governor Greg Abbott reacted to that Supreme Court order by issuing a letter to the Biden administration outlining that the state has a right to self-defense under Article 1, Section 10, Clause 3 of the United States Constitution. The governor makes a claim that despite the Supreme Court's order that was issued, the Biden administration has failed to fulfill their duties to protect a state against an invasion. Therefore, the state of Texas is engaging in their own self-defense. This has set up a significant clash, not only, in the real world, but also in the legal system between the state of Texas and then also the Biden administration. Now, we need to do some background on this case so you understand what that Supreme Court order was and then what has been the impacts after that order. The recent Supreme Court order involves overruling a preliminary injunction that was granted by the 5th Circuit 3-judge panel, which is a court of appeals. The 5th Circuit panel, in that decision, essentially prevented the United States Border Patrol from cutting, destroying, or otherwise interfering with concertina wire or C-wire that the state of Texas had put along 29 miles of municipal and private land in the Eagle Pass area. In this case, Texas originally sued the federal government in the state of Texas and the federal district courts there, alleging that there was a trespass and then also violations of the Administrative Procedures Act, also known as the APA. Originally, in the lower court case in the federal district court, Texas requested that the court there grant a temporary restraining order. And on review, that district court, the lower court, did grant a TRO, which temporarily barred the government, the federal government, from interfering with Texas's operations and the whole C-wire that they were putting up. And the only exception that was in place for that TRO was for medical emergencies. Texas also later then sought a preliminary injunction, which would simply prevent Border Patrol from being able to cut the wire while this case was making its way through the process and was reaching a final judgment. A preliminary injunction is similar to a TRO. The legal standards are very similar, but it's in place for a little bit longer. It stays in place for the duration of the trial. In this case, the lower court granted a TRO, but then later on review, denied the request for the preliminary injunction. What was interesting about that lower court denial of the injunction was the fact that the judge agreed with the state of Texas on multiple issues, including the fact that the government cutting the wire was generally not necessary to prevent medical emergencies. The court rejected the notion that medical emergencies could justify the destruction and the cutting of the fence, essentially leaving it open for medical emergencies. Instead, they would say, why would you need to cut it and then leave it open for one specific medical emergency? Why would you not cut it, open it, help that individual, and then close it back up? Despite all of that, the judge there denied Texas's request for a preliminary injunction. Texas then quickly appealed that denial of the preliminary injunction up to the 5th Circuit Court of Appeals. This is known as an interlocutory appeal. It's an appeal on a middle stage order. It's not an appeal on the final judgment of the case. Now, along with that appeal request, the state of Texas also sought an emergency injunction from the 5th Circuit. They wanted the 5th Circuit to issue their own temporary emergency injunction to maintain the status quo, while the 5th Circuit reviewed whether or not the lower court got that correct or not. And on review, the 5th Circuit ultimately granted that temporary emergency injunction pending the appeal. So this whole dispute that ultimately made its way up to Supreme Court and got Supreme Court review isn't even on the 5th Circuit granting a true preliminary injunction. Instead, all the hoopla and controversy is over a temporary injunction that the 5th Circuit granted to maintain the status quo in Texas while the review was taking place on the appeal. Now, as I stated, the government then sought an emergency application up to the Supreme Court. They asked for the United States Supreme Court to step in early and vacate that 5th Circuit temporary injunction, that emergency injunction, which simply, again, maintained the status quo while the appeal was happening. And on review, the United States Supreme Court issued a 5-4 order, which granted the government's request to vacate that emergency injunction. The emergency application went in front of Justice Alito. It goes to Justice Alito first because he's responsible for all emergency applications that come out of the Fifth Circuit. And then he issued the order, and the court issued this order, and it states simply that application to vacate injunction presented to Justice Alito and by him referred to the court is granted. The December 19th, 2023 order of the United States Court of Appeals for the Fifth Circuit is vacated. Justice Thomas, Alito, Gorsuch, Justice Kavanaugh would deny the application to vacate injunction. So what that means is that ultimately the Supreme Court voted in favor of removing that temporary emergency injunction that the Fifth Circuit put in place while they're going to review this issue. That effectively means that Supreme Court is allowing the lower court's denial of the injunction to go in place. Now, the two judges who jumped the line once again in support of granting this stay was Justice Barrett and then Justice Roberts. Roberts is no surprise because he tends to be middle ground. He's not a true conservative. He, jumps the line quite often. He does that quite a bit. But Justice Barrett, again, was one of those judges who is allegedly conservative, was put in place by Donald Trump. And once again, she is siding with the agency side, the government side, and ruled in favor of granting the stays, which again is kind of concerning. We've seen her do this multiple times in other cases, like the ATF Vanderstock case, in some of these other cases. And we heard recently in the oral arguments of the Cargill bump stock case, it seemed like maybe she was going to side with the ATF. So Barrett's becoming a little bit more of a concern based on some of the things that she's doing. But I want to be clear and fair that what happened here in the Supreme Court is not a final decision on the actual merits of this case. This all involves a temporary injunction that maintained the status quo of the law while this case was being reviewed by the Fifth Circuit. But it's still not good that you have the Supreme Court siding with the government, overruling the injunction, effectively allowing the government to cut the wire in that specific area in this dispute. Now, in reaction to that Supreme Court order, Governor Abbott in the state of Texas did issue a letter to the Biden administration, which kind of went viral and everybody was talking about. Essentially, the governor there said that, despite what the Supreme Court said in that order, they believe that the federal government and the Biden administration is not actually helping them defend themselves, that there's an invasion, and therefore, under the Constitution, the state of Texas and Abbott as governor has the ability to engage in self-defense of not just the residents, but the state of Texas itself. Governor Abbott then called in the Texas National Guard to secure the area and essentially prevent Border Patrol from cutting a wire in specific areas. Now, in response to that, the Biden administration said, state of Texas, you only have 24 hours to allow Border Patrol into the area, which did not happen. And there are some sanctions that the Biden administration is trying to put in place against the state of Texas. But we've seen an overwhelming, amount of support from other states in support of Texas and the state of Texas defending itself in dealing with this border issue. We've even recently seen the state of Tennessee send some of their National Guard to Texas to help them in this cause. Now, after the Supreme Court's 5-4 order granting that stay, the Fifth Circuit Court of Appeals had to respond. The Fifth Circuit has now held the case in abeyance and remanded the case back down to the district court, essentially just for a limited time, 60 days, in order for the lower court to develop that factual record that is needed for the appeal review. So a limited remand is now happening in this case, and some additional facts are being developed at the lower court level. The lower court has ordered that the parties submit documents, pictures, emails, etc., of all border wire that's being disputed, some of the areas, and some of the actions that are taking place. Now, there was also a hearing that took place on March 4th and March 5th. One of the interesting things that came out of that hearing was the issue of whether the district court is only supposed to develop new factual records, new factual evidence in light of what the Fifth Circuit said and in light of what the Supreme Court said in their order, or does the lower court also have the ability to issue a new judgment based on the new evidence that they are collecting? The court stated that they want arguments on whether the Fifth Circuit Court of Appeals remanded this case to the court to make new factual findings only, or to make legal determinations in light of new factual findings to be made after taking evidence. So there the court is saying, both sides, both parties, both the government and the state of Texas, I want arguments on whether or not we're only supposed to be collecting factual evidence, developing the record, or once we get that information, can we issue a new order in light of what the Fifth Circuit said? Now, I still anticipate that the lower court judge here will issue a new ruling. I don't think the lower court judge here is just going to leave it to collecting factual evidence and a new record and then sending this back up to the Fifth Circuit Court of Appeals. Even the Fifth Circuit Court of Appeals, them kicking this and holding it in abeyance, for a development of facts kind of shows that a bunch of different courts don't really want to touch this right now. And I think the lower court here will develop that new information, get the new facts, and then issue a new judgment that then will go up to the Fifth Circuit Court of Appeals, and at that time they will have to address it. So that's where the Texas border lawsuit and dispute currently stands after that Supreme Court 5-4 order. There's a lot of questions about who right now of the lower courts has the authority to issue new judgments, what type of factual information needs to be submitted and developed in this case, and ultimately what authority does Texas still have after that Supreme Court order. Hopefully that helped you guys understand where the case is currently at, what the dispute is. If you guys have any questions, go ahead and comment down below and I will try to answer to the best of my ability. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.